Hello everyone, welcome back to the channel. In today's video, we will break down an important topic from the Code of Civil Procedure, that is the various stages of civil suit. If you are a law student or someone curious about how civil cases progress in the Indian courts, this video is for you. Now, before we dive into the stages, let's quickly understand what a suit is. Interestingly, the CPC does not define the term suit. But in simple words, a suit under CPC is a legal action started by presenting a plaint in civil court to enforce a legally recognized right or to seek relief. Here the plaint is presented by the plaintiff whose right has been infringed. We have all come across this maxim called ubi jus ibi remedium, which means where there is right, there is remedy. Here, the plaintiff's right has been infringed. So that's why he's instituting a suit in a civil court to enforce as well as legally recognize his right and also to seek relief from the court as well as from the defendant. It also serves as a formal claim put before a competent court. Here the keyword competent court is important because a plaint can only be filed in a competent court, which means which has proper jurisdiction to hear that particular matter. So moving on to the key components of a suit typically involves two parties. One is the plaintiff and another one is defendant. The second thing which involves is the cause of action. The third thing is the subject matter in the dispute. And the fourth thing is the relief claimed. Now to understand this, let me give you an example. Let's say you're residing in your house, and let's say this is you, which is person A, and let's say another person B comes into your property and tells you that this property belongs to him. Then what immediately A can do is he can file a suit in a civil court emphasizing that the cause of our action arose on the day when the B came to his house and demanded that this property belongs to him. That becomes the cause of action. And A becomes the plaintiff, B becomes the defendant. And the subject matter in dispute is the house itself. House becomes the subject matter in dispute. And what A can relief claim is he can claim temporary or permanent injunction restraining B from entering his property. That is the relief claimed. Now let me give you a quick overview of various stages involved in a civil suit. The first stage is the institution of suit, which is usually done by the plaintiff by filing a plaint. The second stage is the summons stage, where the court issues summons to the defendant to appear on a particular date. And the third stage is written statement, which is filed by the defendant. And the fourth stage is replication stage, which is filed by the plaintiff. And the fifth stage is framing of issues, which is done by the judge. And the sixth stage is evidence stage, where documents, cross-examination, examination of witness takes place. And the next stage is argument stage. And finally, we have judgment. We will discuss each of the stages with relevant examples. As we all know, the first step is institution of suit, which is done by filing plaint under Order 7, Rule 1 of the CPC. And also it is provided under Section 26 and Order 4 of the CPC. So please have a look at that. So a suit is instituted by filing a plaint along with prescribed court fees as well as proper documents. So the court fee has to be paid, and also plaint can only be instituted in a court which has proper jurisdiction. And also the plaint must disclose cause of action, the address of the plaintiff and defendant, and various facts of the case. Now let us consider one example uh, where A files a plaint against B for recovery of rupees 5 lakhs due under a loan agreement. Here, the party B has taken loan from A of rupees 5 lakhs, but he has failed to repay it. Hence, A has instituted a suit against B for the recovery of money. So the next stage is issue and service of summons under Order 5 of the CPC. So after the plaint is admitted, please pay attention here because the plaint must be admitted in order for the court to issue summons. If the plaint is rejected, then the summons stage will not start. So once the plaint is admitted, the court then issues a summons to the defendant to appear and answer the claims. So usually the defendant has to appear on a particular date which is mentioned in the summons. So, and the summons must be duly served to the defendant. This is usually done by RPAD, which is registered post acknowledgement due. So for example, court issues summons to B, informing him about the suit and directing him to appear within 30 days. So the next stage is that defendant must file written statement, and also he can claim any set off or file a counterclaim under Order 8 of the CPC. Here the defendant has to file a written statement within 30 days, which may be extended to 90 days. But in some cases beyond 90 days also, there is one exception where we can file a application under section 151 of the CPC to provide exemption and file his written statement. And the defendant may also claim set off or file a counterclaim. For example, in our loan recovery case, B files written statement denying the loan, claiming that it was a gift and not repayable. So this is his defense. Next is the replication by plaintiff. This is an optional stage. This can only be filed when there are new facts which are raised by the defendant in his written statement, and if the plaintiff wants to counter those new facts, he can file a replication. For example, in our loan recovery case, A files replication submitting proof of a bank transfer marked as loan and corresponding confirming repayment obligation. In the previous slide, we saw that the defendant was defending, saying that the money was transferred to him as a gift. But here, A is claiming in his replication that there was a proof of bank transfer and it was clearly marked as loan, and hence it is not a gift. Next, we have a very crucial stage, which is the framing of issues given under Order 14 of the CPC. Here in this stage, the court identifies the points of disputes by framing issues of law and as well as fact. Issues guide the trial and burden of proof. For example, in our loan recovery case, some of the issues framed can be whether B took a loan of rupees 5 lakhs. This has to be proved, and whether the loan was repayable, and whether A is entitled to recover with interest. All these questions can be answered through trial by producing documents, examining witnesses, and also cross-examining witnesses. So once these questions are answered, the judge can deliver a judgment. Next is a very crucial stage, that is the evidence stage. So let us see what all happens in an evidence stage. The court records the evidence of both parties. Here the evidence can include documents, and first the plaintiff presents evidence and then the evidence of the defendant will be taken. Witnesses are subjected to examination and also they are subjected to cross examination. In our loan recovery examples, A produces bank statements, emails, and witnesses, and B cross examines them and brings his own witness to claim it was a gift. And next we have argument stage. Here, After evidence is recorded, both the parties present their oral arguments. This helps the judge to understand the merits of the case based on the law as well as the facts. So, in our loan recovery example, A's lawyer argues that the money transfer was a loan, and B's lawyer stresses absence of a written loan agreement. So, this comes to the end of argument stage. And finally, the judgment will be delivered as per Order 22 and Section 33 and 2 of the CPC. The court delivers its judgment after hearing both the sides. The final outcome of this suit is given in the form of a decree. Here, what decree means the operative portion of a judgment. The judgment may include all the facts and substances of a case. The operative part of the judgment is called a decree. Here in our loan recovery example, court holds B liable to repay rupees 5 lakhs with 6% interest. So this will become the operative part of the judgment, and this can be called as a decree. And finally, we have execution of decree, which is given under Order 21 of the CPC and also between Section 36 to 74 of the CPC. Please have a look at it in the Bare Act. So this execution decree is filed if the losing party fails to comply with the decree, and the winning party can file an execution petition. The court ensures that the decree is enforced properly. So when the losing party fails to comply as per the orders of the decree, the winning party can file an application for execution of decree under Order 21 of the CPC. Alright, that's it for today. If you like what you saw, please make sure to give a like and subscribe for more videos.